legalization of cannabis coming up very quickly on October 17th, I wanted to speak to you about two topics that are top of mind for employers. The first one is, what are the new workplace rules? What is the new legal landscape that we're dealing with? And because of these new rules, what as employers do you need to know about the changes? And the second topic is to provide an update on drug testing, which is a topic that we're seeing a lot of renewed focus on right now. So to start, I'll just provide a brief overview of some of the key legislation on cannabis to the extent that it impacts employers. So next week, once the Federal Cannabis Act comes into force, it's going to establish an overall framework for the legal use, distribution, and possession of cannabis. The provinces and territories will also be responsible for determining how cannabis is distributed and sold within their own jurisdictions. So on October 17th, Ontario's own Cannabis Act will also come in force. And of note to employers with regard to that legislation is that individuals will need to be 19 and older to buy, use, possess, and grow recreational cannabis. And there are also prohibitions within the legislation on where cannabis can and can't be consumed. And in particular, the legislation says that it can't be used in public spaces and it can't be used in workplaces as those are defined in the Occupational Health and Safety Act. And medical cannabis is subject to a different set of rules, and it's separately regulated. So we're looking at a different regime for that that's been in existence since about 1999. Okay, so the Smoke-Free Ontario Act, which I summarized very briefly on my slide, is another piece of legislation in Ontario that will have some practical implications for employers. Currently, the Smoke-Free Ontario Act deals exclusively with tobacco smoking and where tobacco can and cannot be consumed. So there was an amended piece of legislation that was supposed to come into force over this summer that had some further requirements, and this is currently under review as a result of the new government in Ontario. So there's a little bit of uncertainty right now as to what this legislation is ultimately going to look like. Because of that, I won't go into too many details about it, but there's some aspects of the legislation that as employers should be kept on your radar. Specifically, the points that I wanted to highlight are that first, in the legislation's current form, it prohibits smoking tobacco and vaping and using medical cannabis in prohibited places. And those include enclosed public spaces and enclosed workplaces. And there's also some posting requirements for workplaces. Again, these are in a bit of a state of flux, so we don't really know what the posting requirements will ultimately look like, or if ultimately those requirements will be kept. In terms of the status of the legislation more generally, in about 2 weeks ago, the Ford government announced that it plans to require recreational marijuana smokers to follow the same rules as tobacco and e-cigarette users. So this has resulted in quite a few questions. What it means, in other words, is that the government's stated intention is to allow recreational marijuana to be smoked in the same spaces as tobacco, with a ban on smoking in enclosed public spaces and workplaces. So if these changes do move forward, and we're still waiting for more information, the implication, for example, might be that individuals have the ability to smoke marijuana, say, on the sidewalk. And to me, this seems slightly contradictory with the Cannabis Act that I mentioned, which says that there will be no recreational cannabis use in public places. So we need to very closely monitor these developments, and we will be making sure that our clients and that employers that we work with are well aware of the restrictions on where cannabis can and can't be used going forward. So weed in the workplace, with all this new legislation in mind, what's an employer to do? What are the practical takeaways? What should we be thinking about now? So In terms of practical takeaways, we really think that the best way to handle the impact of legalized cannabis is to make your expectations clear to your workforce. And really the best way to do this is through a policy or statement. So if you already have a drug and alcohol policy, it's a great opportunity to update it. If you don't have one at all, it's a good opportunity to think about putting something in place. There's really no one-size-fits-all approach to this. Each employer's approach is really going to differ based on their needs and their workplace culture. There's no strict requirements as to what needs to go into a policy. So there's a lot of flexibility here, which is really helpful. And for example, we have some employers that are very happy with a very simple policy or statement, whereas others, and especially when you're getting into safety-sensitive workplaces, you're looking at much more detailed policies that set out very specific responsibilities, protocols, maybe drug testing, which I'll talk about. And in a lot of cases, and probably the most, employers are looking for a bit more of a middle ground. Very generally, and I'll kind of skim over this, the common contents of most policies, and it varies based on the level of detail, is to clearly set out expectations and responsibilities, to clearly set out your approach to alcohol, cannabis, and illegal drugs, to address expectations for social events, and to also acknowledge and address how the organization will handle addiction and accommodation. So in working with clients and working on these policies, and there's been quite a few of them given that the legalization is coming up so quickly, we have seen some common trends in terms of policy contents and sticking points. And I wanted to highlight one in particular, which is a question that we get from so many employers, which is, with alcohol and marijuana now both legal, can we draw a line between the two, or do we need to treat them in the same way? So the answer is that most employers that we've seen really are drawing a line between alcohol and marijuana, both in the workplace and at social events. Most employers want to prohibit the use of marijuana completely. And this is generally fine, but there are some potential gray areas, particularly when it comes to conduct outside of the workplace. And we see that becoming more of a question when we see how this legislation is rolled out and what the expectations or the regulations will be concerning use of marijuana in public spaces. What we can do to work with this problem is make sure that our policies contain a general prohibition against impairment in the workplace, and I would certainly advise that all policies have that component. That way, even if an employee is using or has used marijuana as they're legally permitted to do in a public space, if they're coming into the workplace impaired, they're coming to a social event impaired, we can still take the position that that behavior is not acceptable. So I'll turn now to the drug testing update. So while legalization of marijuana doesn't specifically impact the law on drug testing, with legalization so close on the horizon, a lot of employers are seeking more guidance as to the utility or appropriateness of drug testing. So drug testing policies are from the outset problematic because they can result in adverse action on the basis of disability or perceived disability, and addiction is a form of disability. In other words, these types of policies can result in discriminatory treatment. As a result, a drug policy or a drug testing policy has to be justified on the basis of what's called a bona fide occupational requirement, or a BFOR. In other words, it has to be adopted for a purpose that's rationally connected to the job, and it has to be reasonable in order to accomplish that purpose. It should be linked to job safety, and it should take into account the nature of the workplace, and it also has to strike a balance between privacy and workplace safety. So, a policy that's overly invasive, overly broad, or vaguely worded is most likely going to be struck. Several different types of drug testing policies have been addressed in Canadian jurisprudence. There's a lot of case law on this. I wanted to talk about them. I don't want to go into too much detail, though I did put detail on my slide so that you have it for your reference, but I will turn to those now. So the first scenario that I wanted to speak to is pre-employment drug testing. This is one that we really suggest a lot of caution in respect of. Essentially, there are really only very limited circumstances where this type of drug testing is justified. It may be seen as reasonable where the testing is rationally connected to the employee's essential duties and where it's also part of a larger qualification or job screening process. And generally, this has only really worked for employees who are applying for safety-sensitive roles. But again, you need to be very cautious here, and it's not something that we generally recommend. The next two are reasonable grounds and post-incident testing. And I've addressed these on the same slide because there's some overlapping considerations. With reasonable grounds testing, this can be used where there's an action by the employee or an aspect of their demeanor that would cause someone observing them to reasonably be suspicious that they're impaired. Again, where there's no signs of impairment, this type of testing is just not justified. The employer should also take very seriously whether there's other less intrusive methods of assessing the employee's behavior. So for example, if you can simply allow them a chance to explain, perhaps remove them from work, bring them back to talk about things, engage in performance management, and you're still able to assess the situation, you may be achieving the same purpose without having to do drug testing, such that your drug testing may not be justified. With post-incident testing, this can be used as part of a larger investigation into a significant accident or what's called a near-miss incident, so something that had the potential to result in an accident. For this situation, there should be no external explanations besides what the employee did or how they acted as to what caused the incident. So for example, if you had an issue with equipment, but there's no other signs of impairment, you're not really in a situation where drug testing will be appropriate, where there's an equipment-related accident. I have an example there on my slide which illustrates the post-incident testing, and that was in respect of what's called the Jacobs industrial case. And this case involved a 65-year-old employee who backed into a parked car in a parking lot, something that maybe some of us have done before. I don't know who. The employer in that case wanted to require drug and alcohol testing, and the employee refused, and then he was terminated. He actually didn't show any signs of impairment. He had no known history of drug or alcohol abuse, and he didn't have any disciplinary record. So on review, the arbitrator found that the attempt to impose drug testing was unjustified and an unjustified infringement on his privacy rights. So just to underscore that you really need to have that indication of impairment. The next form of testing is return to work testing. This can be used in respective employees who have had a history or an incident involving drug or alcohol abuse at work in connection with a return to work protocol, usually in connection with a safety-sensitive role, I would say generally. And what a return to work protocol is essentially is it's a program that the employer puts in place that requires the employee to undergo drug testing, usually unannounced. And if they test positive for drugs, then they'll be subject to further discipline and often termination of employment. These policies can work usually in safety-sensitive roles, but they should also provide or build in flexibility so that each situation is being assessed on its own merits and on a case-by-case basis. So the last sort of form of drug testing I wanted to canvass is random drug testing, and this is probably the one that we get the most questions about, the one that we see the most in the media, probably the most controversial. So similar to the other scenarios, random drug testing should only be conducted where a link can be established between impairment and workplace safety. However, random testing is not automatically going to be justified because a workplace is dangerous or because employees are in safety-sensitive roles. Instead, you have to have evidence of enhanced safety risks in the workplace, like evidence of a general problem with substance abuse or something along those lines. Unfortunately, however, there really is not a lot of case law as to what actually constitutes an enhanced safety risk. Employers have tried to show this, but have had difficulty proving it. In the Ticoll example that I have on my slide, this involved a drug policy that was challenged, and in support of its policy, the employer brought forward a number of employees who testified personally about their individual battles with drug and alcohol abuse, and they worked in the context of a safety-sensitive environment. One might have thought that the testimony of a group of individuals with these types of problems would have been sufficient to show a general problem, but it wasn't, and the drug policy was ultimately found to be unreasonable. So for employers who are actually looking to implement drug testing, I do have one case to talk about that's quite helpful. The recent TTC decision, which I've cited on that slide and which I'll talk about in more detail, sets out some really helpful benchmarks, which I'll turn to. So before I get to the takeaways from the TTC decision, I'll give some context. In 2010, the TTC introduced a new fitness for duty policy, which was challenged by the union. 6 years into that grievance, the TTC advised that it was going to be implementing drug testing, or random drug testing, and it included testing of employees in safety-sensitive roles and also some executives. The union filed for an injunction, but that injunction was refused. And in making the decision to refuse the injunction, the court gave some very helpful assessments and conclusions. First, it gave specific regard to the public safety issues that were at play. It noted, in particular, that drug or alcohol misuse by TTC employees could have tragic consequences for many people. The court also drew significant attention to a significant amount of evidence that was tendered by the TTC in support of its policy. It entered evidence about the culture of drug and alcohol use that existed. It also entered expert evidence about the deterrent impact of drug testing, which was shown to have significantly reduced the risk of impaired persons causing an accident. It highlighted communication, that the TTC had distributed comprehensive information to all employees about its policy. And it also highlighted that the policy provided for treatment for drug and alcohol use for employees who tested positive where that was appropriate. So it acknowledged that disability and accommodation aspect. And finally, the court also examined the TTC's actual testing processes, and it determined that they were minimally intrusive and superior to other methods of testing that are available on the market. And while this is quite detailed, I think that this aspect of the analysis was very helpful on a practical level for employers who may be seeking to implement drug testing. So the specific aspects of the policy that it highlighted were that it used breathalyzers and oral fluid samples, which is basically like cheek swab testing, as opposed to the more invasive blood testing and urinalysis options that are available. Also, an employee who received a positive test result would have those test results reviewed by a medical officer who would discuss the results with the employee and have the ability to rule out legitimate explanations for a positive test. So for the example, the taking of medication that might have impacted the test. And the test also used very high threshold levels for a positive test, which ensured a greater likelihood of impairment on the part of the employee at the time of testing, rather than identifying past use. So, as the TTC case shows, a workplace policy is really essential for the implementation of a drug and alcohol testing program, as is a very well thought out testing protocol. I've outlined on my slide some of the essential components of what we would look for in a drug testing policy. Briefly, what we would want to see are a clear outline of the employer's expectations, responsibilities of employers, supervisors, and employees, testing protocols and methodology, consequences of a policy breach, confidentiality should be addressed, and also training. This is really important if you have reasonable grounds or post-incident testing, where you're going to have supervisors or managers identifying potentially problematic situations. And then you also want to address addiction and accommodation as appropriate. So again, like I talked about before, these policies really should be individually tailored. They should reflect each employer's specific workplace needs and the safety issues at play, if there are any, especially if it's a safety-sensitive workplace. And all in all, I would say that this area of law is highly contextual. There's no one-size-fits-all approach on how an employer should approach drugs in the workplace, be it for a safety-sensitive workplace or a non-safety-sensitive workplace. But we also have to remain cognizant of the fact that with legalization of marijuana, we're entering into new and uncharted territory. With time, what I do think we'll see are trends emerge. We'll have a more firm idea of what the legislation will be, the legislation will actually be cemented, and we'll also have the benefit of more case law to guide employer actions. And these are all topics that we will keep you posted on. So with all of this in mind, I will turn the podium over to my colleague Allyson, who will speak about cannabis and benefit coverage.
Good morning. So Tamara is taking you through some aspects of cannabis in the workplace. I'm going to shift focus to another aspect of marijuana in the workplace, and that's marijuana under benefit plans. So I'm going to start by building a little bit on Tamara's discussion of the regulatory landscape. This will provide context for my discussion of marijuana under benefit plans and some of the case law. So bear with me as I take you through it until I get to my point. We'll then move over to discussing some options and considerations for plan sponsors with respect to providing coverage under benefit plans. So right now, cannabis is a controlled substance under the Controlled Drugs and Substances Act. It's also listed as a drug under the Food and Drugs Act. So basically that means that activities related to cannabis are essentially prohibited unless they're authorized under certain regulations like the Access to Cannabis for Medical Purposes regulation. So together, the CDSA and the FDA regulate various aspects of cannabis use, production, possession, distribution, and specifically the FDA regulates the sale of health products containing cannabis. So when the Cannabis Act comes into force, cannabis will remove from the CDSA as a controlled substance, the Access to Cannabis for Medical Purposes regulation will be repealed, and all those regulatory matters will move under the Cannabis Act. So the Cannabis Act and the FDA will sort of continue to interact in a manner that's similar to the way the CDSA and the FDA currently interact. So Cannabis Act will control the matters of production and distribution and sale and possession across Canada and address concerns of diversion to the illegal market. And the FDA will continue to regulate matters of cannabis and health products, the safety, efficacy, and quality, and specifically health products that make health claims. For example, it reduces cold symptoms. These must be approved by Health Canada. So, almost at my point. Once a drug is reviewed and approved by Health Canada, it's issued a drug identification number, which is an 8-digit number that tells people that it has Health Canada's approval. So when benefit plan sponsors are deciding what coverage to provide under their plans, a really common approach is to provide coverage for benefits that have a drug identification number. So medical marijuana itself does not have a drug identification number. There are some medications containing cannabis that have a drug identification number, but my understanding is that Health Canada just isn't convinced of its effectiveness or that its benefits outweigh the risks. And so for that reason, it hasn't actually been issued a DIN. So in practice, what this means is that most benefit plans do not provide coverage for medical marijuana. The HRPA did a study apparently that showed that only 4% of benefit plans surveyed provide coverage for medical marijuana, and the reason cited was the absence of Health Canada approval. So this DIN requirement has actually been a really useful tool for employers in defending challenges for the non-reimbursement of medical marijuana. I won't go into detail for any particular case because the facts are generally fairly similar in each of these cases. In each case, the claimant identifies medical marijuana as the only effective treatment for their condition or their symptoms. They're refused reimbursement under their benefit plan because the benefit plan requires a drug identification number. And in each case, the decision makers found that the requirement for Health Canada approval is a reasonable, non-discriminatory limit to place on plan coverage. In one case in particular, Skinner, the Nova Scotia Court of Appeal, sort of described the reasoning very, very well. Refusing Mr. Skinner a drug not approved by Health Canada does not differentiate him from others disabled by chronic pain. No beneficiary received medical marijuana. No beneficiary received drugs not approved by Health Canada. The plan's exclusion of such drugs was not based on Mr. Skinner's disability. So, to the extent the new Cannabis Act and the FDA will sort of continue to interact in a manner similar to the way the FDA interacts with the CDSA right now, I think it's fair to say that plan sponsors who continue to limit coverage under benefit plans to drugs that have a DIN will likely successfully defend any challenges for non-coverage of medical marijuana. Having said that, now that marijuana is legal, the demand for coverage may increase. And over the next few years, coverage may be expected as part of a basic suite of benefits. One study Sanofi did indicates that 64% of plan members expect medical marijuana coverage, but really only 34% of plan sponsors thought it should be covered. And the HRPA study that I referred to earlier indicated that that 78% of plan sponsors surveyed said they really had no plans to take any action to provide coverage for medical marijuana. There's already a bit of a disconnect between plan members' expectations and plan sponsors' expectations. So to the extent plan members have indicated there's a demand, the case law shows that there's a demand, and as we'll see, some insurers have identified a demand. What are the options for plan sponsors to address this demand? So one option that exists already is a healthcare spending account. The Canada Revenue Agency has developed guidelines for coverage of the medical marijuana as an expense for the tax credit. And so provided it qualifies for the tax credit and meets those requirements, individuals can claim coverage under a healthcare spending account. And no DIN would be required. Some considerations involving healthcare spending accounts is that they have limits that may not fully address coverage needs, but then at least provide some coverage. It does provide flexibility for plan members and doesn't require the employer to open up their plan to drugs that do not have drug identification numbers. But it does provide less control over the coverage. And so some of that can be mitigated, some of that risk can be mitigated through an administrative services arrangement with an insurer, which is what we would suggest puts a little distance between the plan sponsor and the decision making. And the ASO provider can put some parameters around coverage and ensure compliance with the Canada Revenue Agency. If a plan sponsor is considering expanding coverage under their extended healthcare plan, I understand some insurers have offered or developed add-ons to their group benefits plans. Sun Life, for example, has an add-on for medical marijuana that does not have a DIN. I understand Green Shield also has an add-on. They've incorporated certain administrative procedures to protect against misuse and provide a degree of control over claims. For instance, they would have a list of conditions or treatments that they would accept for coverage for medical marijuana. The risk is that different insurers might have different lists. So my understanding is that, for example, Sun Life and Green Shield have different lists of items that they consider as sort of valid conditions or treatments or symptoms to be treated by medical marijuana, which I think illustrates somewhat the risk of opening a plan to drugs without a drug identification number. You lose the consensus that comes with the DIN requirement, the consensus that Health Canada approval provides, and suddenly it becomes a little more subjective. So if you consider, for example, the cases we discussed very briefly earlier, where the plan member argued that medical marijuana was the only effective treatment for them, in the absence of a clear delineation that a DIN requirement provides, the door is sort of open to debate about what should and should not be covered, especially since Health Canada has also said that there's really not a lot of empirical evidence about effective treatments. So it sort of opens the door to debate. Other products or services offered by insurance companies include, I understand Manulife is working with Shoppers Drug Mart to provide support and advice for medical marijuana use for group plan members. This type of coverage, the healthcare savings account and any add-ons to group benefits should really be considered also in the context of your workplace policies regarding marijuana use. The two should be consistent. So the takeaway for employers at this point, it appears that the regulatory changes won't directly impact the current approach. So if you have a plan where a DIN is required, it seems that that will still be considered to be a reasonable limit. But the change in the law might sort of indirectly necessitate a change to your benefit plan to meet the growing need of, or the growing demand of your plan members. So picking the right approach that balances the risk of expanded coverage in order to meeting those demands for coverage is going to be a challenge for plan sponsors, especially until the law develops under these new rules and these new plan add-ons are challenged in court. So this concludes the medical marijuana portion, or the marijuana portion of the session. I'm now going to shift gears and move into a year in review. So I think Alex and Calfam will join me. If there's anyone who wants to sit at the table, now's a good sort of transition time. No, sitting is a new smoking. So I'm going to discuss an emerging trend in the area of discrimination under benefit plans, and then my colleagues Calfan and Alex will continue the discussion with some recent legislative and case law developments. I'm going to open with a summary of a recent case involving discrimination on the basis of age for an employee over 65, which I'll discuss in a bit more detail. And then I'll touch on a few other cases that are in the same vein, one also involving age discrimination and two others involving discrimination on the basis of marital status. So the first case I'm going to discuss in a bit of detail is Talos and the Grand Erie District School Board. Mr. Talos was a teacher. He continued in employment after 65. But at 65, the school board terminated his health and welfare benefits, and this was consistent with the plan terms and the collective agreement. Now, Mr. Talos had a very specific situation. He was working in part because his wife had a medical condition that placed a financial burden on the family. So he needed the income from his employment, but he also needed the benefit plan, which covered off some of his wife's medical expenses. His wife did not have her own employment plan, and she was younger than he was, so she didn't have coverage on some certain government benefit plans. So when the school board terminated his health and welfare benefits, Mr. Talos filed an application or a complaint with the Human Rights Tribunal, claiming discrimination under the Human Rights Code. He really filed two applications. The initial application was a claim of discrimination under the Human Rights Code, but the tribunal held that the code provided a complete defense for the board to the claim because when the Human Rights Code was read with the Employment Standards Act and its regulations, it did not protect workers over the age of 65 from age-based discrimination. So Mr. Talos filed a second application related to a charter challenge, saying that the section that the board was relying on as a defense did not protect workers over age 65, and so constituted age discrimination contrary to the charter. So the tribunal held on the charter challenge that the provision that the board was relying on as a defense removes protections for older workers, and in doing so is discriminatory to those workers. The financial viability of health and welfare plans can be achieved without depriving older workers of recourse to a human rights claim. And the provision is not saved because it doesn't require the employer to demonstrate exclusion from benefits is reasonable, justified on an actuarial basis, or that the inclusion of older workers would cause undue hardship to the plan. So the result was that the tribunal sent the initial human rights claim back to be reheard and redecided. But we don't have a decision in that case yet, so we don't really know the outcome. But what this charter challenge decision and a few other decisions, charter challenges that in the next slide alert us to as a potentially emerging trend in discrimination under benefit plans. So the other cases I'm referring to are these three cases here. I'm not, again, to discuss any of them in great detail because some of them are in the early stages yet. But I want to walk through them at a high level so you can get a better sense of the trend. The first case is also an age-based discrimination claim. And in that case, the tribunal dismissed the plan sponsor's application for a summary judgment on the basis of similar complete defense provision under the BC Human Rights Code. So the complainant has made out a prima facie case of discrimination, and the complaint will be heard with the charter challenges in mind. The next two cases involve challenges to pension plans. One is CPP, and the other is a union-sponsored pension plan. And the challenges are on the basis of marital status. They relate to an enhanced joint and survivor pension that is provided under the plan, which essentially provides a benefit of greater value to married members relative to the benefit provided to single members. So both of these challenges will be heard taking into account charter values. So although we have no decisions on the charter challenges in the other three cases, and the tallow case is not law, they do represent a shift in thinking, which may just be a reflection of the changing demographics of the workforce. It's interesting that in one of the cases, Duncan, from the previous slide, which was a judicial review, the court ordered that in hearing the discrimination claim for the marital status discrimination and the charter challenge, the tribunal was to consider the policy rationale underlying the exemption for discrimination on the basis of marital status and benefit plans. I think this highlights the shift in thinking that Talos and these other cases represent. All of this suggests that this area of law may continue to evolve over the coming years as these decisions are rendered and more challenges are filed.